तो इस तरह के हिसाब से ठीक है।
ठीक है सर, कॉन्टैक्ट रहेगा।
ठीक है।
थैंक यू।
और सब बढ़िया।
बढ़िया बढ़िया।
कॉलेज का कैसे है, 2-3 दिन कैसे करेंगे?
अच्छी चीज़ ये है कि मेरी इस टाइम कोई क्लास नहीं है, वेडनेसडे में होते हैं।
अच्छा
और आज जो मेरी क्लास है वो 2 बजे के बाद है,
अच्छा
तो वो लकीली वो सेफ टाइम है। पहले मंडे ऑफ होता था और वेडनेसडे ऑफ होती है, तो वो सेफ मैनेजेबल है।
चलो ठीक है, अगर वीडियो तो बता देना।
Namaskar. Welcome to the very first session of MMPC 13 Business Laws. In this course, we have got 6 blocks and a total of 16 units covering various aspects related to business laws, including the concept, start, and the dimensions of various business law that have evolved over the period of time, including the recent one and the modifications that are incorporated over the period of time due to changing scenarios, new business procedures that have been evolved, including, like example, previously we could not have imagined the concept of electronic commerce or e-commerce business. We could not have imagined that a person will be just looking, identifying, selecting a product on its screen and paying for it and receiving the product at its doorstep. So this kind of evolution in business model also attracted change, upgradation, and modification in the business laws as well. So we will be exploring, try to explore all the possible dimensions from starting to the current scenario. Well, as far as the first block is concerned, it is basically overview of business law, including introduction to business law, various concepts and principle. And in the first unit, we have got introduction, meaning business, business environment, etc. So let's explore what is exactly business law. Well, the business law and business laws, basically these are the terms that are used interchangeably. And usually business law is a generic or umbrella term which provides legal and regulatory framework for doing business. Well, business environment is in any country governed by its business laws that are necessary for conducting business transactions and regulating business. Well, this is altogether necessary because in the business, the first and foremost requirement is investment or financial aspect. Then there is another aspect, that is manpower aspect. And then there is another aspect, that is the product. So the money that is invested in the manpower or a raw material or a combination of raw material and manpower resulting to the product, and the product is sold, and during this cycling the invested money grows. So anyone, any investor, or maybe a domestic investor, or maybe a foreign entity, or maybe anyone who wish to invest his money in any entity, wants a certain safeguard to its investment. Safeguard in terms of that he is safe, secure, and whatever business he is doing under the umbrella of law is protected by the proper legislation, and he can defend, or the administration or the government is in support of the activity what he is doing under the umbrella of law, and his rights, his resources are protected. So basically, business laws are related to them, and as well as the various concepts that are necessary for effective functioning of the market in the modern nation, maybe one law, second the rule of law, and third is the property. Well, as far as the law is concerned, definitely under simple definition, law provides that law is a formal social force, is made up of rules which are laid down by the state and are backed by the enforcement. So the important aspect is the backing of these laws by the enforcement. Then rule of law. Well, as per the Secretary General of United Nations, without confidence based on the rule of law, without trust and transparency, there could be no well-functioning markets. So I think this definition itself is very perfect in saying that without trust and transparency, if there is no trust, no transparency, there could be no well-functioning markets. Well, without the rule of law, major economic institutions such as corporations, banks, and trade unions would not function, and the government's many involvements in economy, regulatory mechanism, tax systems, customs structure, monetary policy, like would be unfair, inefficient, and opaque. Well, as for the last component concern is the property. Well, in property, there is one contract law which enables an owner to exchange resources at a future date. Well, tort law compensates owners whose resources are wrongfully harmed by actions of others. Well, criminal law punishes those who harm an owner's resources in a particular way, or in the law of business organizations, how individuals can own and use private resources in groups. So these are the basically various umbrella of rules, we can say, umbrellas of laws, which facilitates ownership of the property, which facilitates transfer of property, and various other dimensions with reference to property. Well, if we look for the meaning of a business, it can be defined as an enterprise or organizations involved in an industrial, mercantile, or commercial activity, may be brought forth for a profit purpose, or can serve non-profit purposes supporting a charitable or social cause also. Well, it may be referred to the activities of an individual or a group of individuals engaged in the sale of goods and provision of services with a profit motive. However, there is a concept of non-profit purpose also. Well, businesses may vary in size as measured by the number of employees or by sales volume, etc. But all businesses share one common purpose, that it is to earn profits. Well, what is to be done with that profit may matter differently, but usually the aim is to run a cycle or a sequence of cycles which results into enhancement in the capital that is invested. So indirectly, the ultimate aim is to earn profits. Well, the purpose of business that goes beyond earning profits are an important institution in the society for the supply of goods and services, creating job opportunities, offering better quality of life, contributing to the economic growth of the nation. Well, on the parallel ground, business law, also commonly known as commercial or mercantile law, is that branch of law that conducts the relationship between the enterprises, companies, and individuals engaged in commercial matters. Well, the section of law governs issues in relation to the legal rights, duties, and liabilities of entity engaged in business transactions. Well, one interesting point, one important point is, well, definitely we wish to earn profit out of our investment, but the activities that can be performed under the provisions are that I mentioned in the previous slide also. So any activity that is legal allowed under the umbrella of So, if gambling is prohibited, so gambling definitely is intended to earn profit. But if it is prohibited or it is not allowed as per the law of land, so definitely it's not a business. It's not an applicable business. So it is definitely a illegal activity, and the land of law will take its course in taking deterrent action or type of action that are allowed over there. But at the same time, if gambling is allowed with the permission, so license is required, certain conditions are required, age group or sort of thing. So only then that kind of business also take place. So there are 2 points, two sides of the coin. One can do type of business which is allowed, and if there is some restrictions, so with license, that kind of activity can be taken. Well, business law is the body of legal rules regulating business activities, and they can be defined. We can have additional definitions as well. Business law is that portion of legal system which guarantees an orderly conduct of business affairs and the settlement of legitimate disputes in a just manner. Well, business law establishes a set of rules and prescribes conduct that enables us to avoid misunderstandings and inquiry in our business relationship. Well, as far as the business environment is concerned, well, definitely business, we definitely look for a profitable venture. We look for investment and return back enhancement in our investments in the form of profit. Well, but this business itself is dependent upon the internal as well as the external forces. Well, internal factors that may be within that are within the control of business entity, whereas the external factors are, on the other hand, include factors that are beyond the powers of control of any business. Well, they in synchronization, both internal and external factors keep on changing and are dynamic in nature. Well, external factors also include laws, regulation, policies that affect the conduct of business and that are altogether beyond the control of the persons involved in the business. Well, if we look for a dimension of a business environment, it maybe we can say it's a complex in itself. Well, it is related to each other, maybe taking partners who are involved. They are related to uncertainty is definitely in any business you can't predict. Well, in current scenario, you can see if you see the IT sector that was growing very fast pace. In the recent past, if you look for a couple of months, there is a sequence of retrenchment activities taking place in almost all the major IT giants. There is a retrenchment in Google. There is retrenchment in Twitter. I think you're very much aware about the recent retrenchment trend, specifically in the IT sector. Other sectors are also showing similar trends. Also, you can see how uncertain is there with the employees, how uncertain is there the expected profit out of business environment. So, business environment definitely is a complex scenario. Well, we understand the significance of business law. Definitely, the main aim is to provide an orderly treatment of business affairs, which facilitates the regulation of commercial activities, well, definitely in accordance with practices of law, and provides for settlement of disputes in an amicable manner. Well, any law or any activity which has got certain objectives, similarly business laws are set up with the specific objectives. Well, the first and foremost objective should be to set up comprehensive set of standards which are universal in nature. Means they are not no biasness. Otherwise, there will not be any partnering participants in it. If it is universally similar or for setting up the universal standards, definitely it is one of the major objective of any business law. Well, it is intended to promote for industrial growth. As I mentioned, for any activity or commercial activity, there is a need of investment or input of money, and that investment definitely results into growth of the nation directly. At the same time, it involves growth of industrial sector also. So these business laws are there to facilitate industrial growth. Well, it lays down the procedures for establishment of business, how to start a business, what can be the structure of business, what will be the who's going to govern, what will be the after effect if there is some change in the management, how to take over the management, how to transfer the ownership, how to distribute the profits, what are the terms and conditions, like that. Then enforcement of rights. So if there are some partners in any business activity, what are their rights? if one partner is not, you can say, mighty or forceful, so even his rights are also protected. Well, it is intended to build a healthy business relationship. Well, if the rules or laws are of transparent manner, set up in a transparent manner with the honest intention, so definitely they are going to build a healthy business relationship among the partner agents. Well, it reduces the possibility of fraud. It maintains an equilibrium. Well, in order to maintain definitely an equilibrium, and definitely the concept of establishment of ethical conduct. Well, if we can say so, the concept of ethical conduct in light of a very recent judgment in some certain cases. Well, you often see certain advertisements where there are brand and ambassador. These celebrities are promoting certain products. So those celebrities promoting certain products. So based on their fan following, based on their inclination to what they say, a lot of people follow them, and later on they end up in a situation where they find that the product that was promoted by the celebrity was not up to the mark as it is claimed in the advertisement. So in order to ensure that it is in ethical manners, there has been recent voices saying that if some celebrity is promoting a product, he or she should initially should test or use that product as well. So hopefully in future we will be comfortably getting products in the market or advertisement in the markets which are actually used by celebrities, or they are promoting actually what they are claiming or to for us to use. Well, then there's a recent trend of social responsibility in the industrial sector, which has been legalized under business law also. So, social responsibility, it is believed that definitely corporate sector is earning profit, they are investing and getting return back a reasonable amount of profit out of their business activity. So it is assumed that these corporates also have some social responsibility to reach to the unreached segment of the society, because government cannot reach everywhere every time, and the presence of corporates are there everywhere in almost every part of the world, every part of country, every part of state or city. So they are quick enough to respond. They are quick enough to address certain issues which may be minor, which may be major, but they are directly affecting the population. So, the activities like addressing the environmental issues, addressing the social healthcare issues, addressing the education related issues. So nowadays, you see a lot of major corporates are setting their own foundations or trusts where they are doing those the intention or aim for those foundation is to do charitable work. You might use the word charitable, maybe maybe very different type of word, but usually the intention is to express themselves as a socially responsible participant in the society. So they do take place in the activities, a variety of activities as a part of their social responsibility. Although the concept of social responsibility is mandated for the organization with a specific type of their turnover, their profits or sort of thing, but still it is expected from the smaller entities to also contribute in that direction. Well, laying down the procedures in according to evolving standards. Well, as I mentioned in the very beginning of the slide, that the very beginning of this discussion, that we can't predict the future. So any law that has been formulated so a couple of years back, maybe 100 years back, may have been tested with the time over the test of the time, and then it may be found that there's need some modification in it, and there has been some evolution in the entire concept, and out of this evolution there is a need to modify, remove or upgrade that law. So definitely, the one of the objective of business laws is to lay down the laws in according to the evolving standards, and that we can see with reference to the Companies Act that has been upgraded over the period of time, and the recent version is available. Well, there is a main desire or objective of business law is to anyone who is following law, it's very good, but there may be someone who is defying the law, who is challenging the law, or who is misusing the loopholes of the law as well, directly or indirectly. So there must be some provisions to penalize for those who are violating the laws. So this is one of the objectives as well. And then we can see or relate a couple of examples in the recent past where uh, we see a lot of businessmen who cheated. I use the word cheated. The public trust. They looted the public money from banks or other agencies. They stash that cash to foreign countries. They leave the country. And now countries looking after them, chasing them. Those people are facing legal actions in different places and expect their properties in the country has been seized, acquired, and auctioned to recover the money that has been taken by them. So this is the live example of implementation of business law for regarding penalizing those who are violating laws. And the last one objective that is last may not be last, it is still newly added. So insurance against the risk. As anyone is investing in any business activity to get a return back, but at times it may be possible there are certain things which are beyond the control of any business entity entrepreneur, and he may incur loss. So under such scenario, there must be some provisions which ensures the safeguard of those risks. So it may be in the form of insurance, well, it may be in the form of compensation. So, like for example, if I take a person takes a housing loan, so there is a provision of insurance of that housing loan in case the person who was supposed to pay it met some unfortunate incident and is not capable of paying because he is no more. So his entire loan is insured, and the uh, other family members who were left behind were not supposed to pay the remaining loan because it is paid by through the insurance. So that is one safeguard. Well, in the meantime, at times, what happened is government also takes favorable steps. So we see the recent pandemic of corona, specifically in Indian context. So in that context, the government has taken up sincere, serious efforts in order to ensure that those who are facing problems out of uh, pandemic, maybe their industry is not functioning, whatever they're producing is not in the market, they are not able to run the cycle of the business. So for that purpose, there has been leverages, there has been schemes that have offered by the governments that may be altogether a different aspect, but overall, insurance against the risk is also one of the objects of business law. Well, as far as the scope is concerned, they are definitely very vast. It takes into its ambit the laws related to all the activities providing indispensable for the successful conduct of the business. Well, they are not restricted to laws related to companies, but it's also provide laws for business activities conducted by other forms of business organization to deal with contracts, property, agency negotiable instruments, sale of goods, bailment guarantees, intellectual property, etc. Well, corporate laws, security laws, competition law, foreign exchange laws, tax laws, etc. Proper commencement of business activities for the required conduct during its life cycle, with finally laws laying down procedure, directing the regulation and culmination of the business activity in consideration. Well, there are also corporate restructuring under this law. Well, corporate restructuring is a process whereby a firm looks to enhance its shareholder value. Broad range of transactions within its ambit, including within its purview, changing its capital structure through infusion of high level of debts to selling of business lines or making acquisition by taking over corporations and making internal changes in the organizations of the firms. Well, company may also look to restructure its business via merger and amalgamation, merger through absorption, merger through consolidation, acquisition, takeovers, disventures, demerger, joint ventures, and buyback of securities, to name a few. Well, restructuring also supervised by different branches of business law, such as Companies Act, FEMA, Taxation, SEBI, etc. Well, this is altogether required because there may be possible sort of monopoly may be there, where there is a big player in the market and there is a small player in the market, and the products out of from that small player is challenging the business of a larger player, and the big player uh, perform use some mighty tricks to tackle that small player. So to address all those issues, there are laws also. Well, if look around, what are the sources or what can be the sources of business laws? So business laws are altogether not a different one. Usually, in terms of definition with reference to law, what is the concept of why or how the laws are sourced or generated? So there may be certain sources. It may be through constitution. So constitution is the spirit or guiding force. So from constitution, statutes, and from statutes to cases. So maybe it may be possible that there is certain unusual situation where two parties reaches to the honorary court, and court based on best possible knowledge, understanding, or belief or transparency, they may bring about with some judgment depending upon their capacities. So those cases may be subsequently cited and take a reference may be taken in the future also. There may be customs for business activities. So those customs which are there in the business activity, maybe taking loan, maybe taking interest out of it. So accordingly, there may be certain business laws in this direction. Then there are treaties between two countries, treaties between two partnering organizations on the national and international levels, or on the basis of those treaties, business laws may be formed. Then government policies may be one of the major source for the business laws. Like, for example, usually if you set up an industry, there is a taxation procedure. So if you start a business, there will be tax. But at the same time, if government decides that we wish to encourage the business in a specific area that is not at all business friendly in many ways. So to encourage the business in those places, government may give some leverages, may give some relaxation, maybe give some tax holidays sort of thing. So out of those features, it also gives a source for business law. Well, let's move to the next unit. It is regarding the concept and principles of business law. And under this unit, we will be exploring the concepts, principles, statutes under business law, basic schemes of litigations, resolutions through courts, and one of the most important one, that is alternate dispute resolution mechanism. Well, definitely, business law provides legal and regulatory framework for doing business. It includes study of legal compliances related to any business activity. Well, it may be established for production, manufacturing, provision of services, or sale of purchase of products. Every such objective involves a complex set of contracts, transactions, and payments. Similarly, in what form business has to be done requires deliberations about the type of business, organization through which the business will be conducted. Well, there are certain principles, as I mentioned. The principles for business law include law and morality. As I might mentioned, anything and everything that is not allowed under the umbrella of law, it may be immoral or so, or it is not allowed or not acceptable. So that is not at all allowed. So there must be business laws to address certain issues. Then business ethics, then common law. So if there is certain common law already prevailing, that may be also a source or principle of formulation of business law. Then there may be certain natural laws. So natural laws, like anyone who is owning that property is supposed to get some return out of it, and that return must be something to compensate his belongings and other things. So similarly, natural law is also added as a principle to business law. Well, there are certain contractual principles. So that also adds to the principles of business law. Then equity and fairness, and this is one of the most important aspects as a principle of business law. There should be equity and fairness in transaction. There should not be any tilt or any undue advantage to one party with reference to other on account of anything we can say is with the color, caste, or gender or so. So that should not be there. It should be the equal and the fairness in light of the law. Well, in any business activity, there are two participants. One who offers, that is called as offerer, and another one who is offering, who accepts. So offerer makes an offer to the offeree, and offeree has the power to accept the offer and create a contract. Well, there are certain statutes under business law, and some of the legislations we can connect or in the current scenario. Well, starting with the ancient and older one, that is Indian Contracts Act from the time of 1872, then Sales of Goods Act 1930, Negotiable Instrument Act 1881, Indian Partnership Act way back of 1932, and Limited Liability Partnership Act 2008. Well, here you see there is a concept of Indian Partnership Act of 1932 and the LLP Act of 2008. So previously, the most of the business were done on the basis of certain acts, contract or partnership act. But it has been realized that there may be other forms of business also. So to address that, there is a concept of LLP was bring forwarded, and it formulated as an act in 2008. Then Companies Act 2013, it is the upgraded act. Then employment and labor law, tax laws, antitrust laws, finance laws, securities laws and regulations, international business laws, foreign exchange laws, Consumer Protection Act 2019. Well, if I say foreign exchange laws, you can see, well, usually investment may be in one country from another countries also. So what can be the rule for that foreign transactions, foreign exchange transfer, how it will be governed, what are the sectors that can be investment can be done. So to address that issue, over the period of time, the concept of foreign exchange become very important aspect. So thereby foreign exchange laws is also very important aspect in this regard. Then Consumer Protection Act, as you see in 2019. So if we talk about equity and fairness, ideally the business law intends to favor the business entity or anyone entrepreneur. Assumably we can say so, but not this is not the case. The consumer is also a component in business, any business. So if we take the consumer as a component, so definitely there must be some provision to safeguard the rights of a consumer. So in order to address that, Consumer Protection Act 2019 was formulated, and it is in place. Law of arbitration. Then about all these, another addition in the form of intellectual property law. So this intellectual property law itself is a combination of acts. It involves Patent Act of 1970, the Copyright Act of 1957, the Trademark Act of 1999, and Designs Act of year 2000. So here you see the concept of patent, copyright, trademark, and design. So I think there's a separate unit in this regard also. So they are all together there. Maybe we joined some of the this concept of IPR a little late or so, but we can see we are quite updated here, and you can see the IP is very important and very relevant in the current scenario. The way we are facing challenges in the global market. So we are supposed to ensure that originality or the innovator should be properly paid. For that purpose, the IP laws should be very strict or should be very accommodated as well. Then there is insolvency law, then the Commercial Courts Act of 2015. So this way we have seen a wide variety of laws that are there. Well, as far as the basic scheme of litigation resolution through courts is concerned, well, definitely, Supreme Court is at the apex, being the union of judiciary. Well, Supreme Court is empowered to exercise original, appellate, and extraordinary jurisdiction. Well, state judiciary comprises of high courts entrusted with the power to supervise the functioning of all the other lower courts and tribunals in the country, including district courts. Well, adjudicatory courts are categorized into civil courts and criminal courts. Well, India follows the concept of adversarial forms of system. In adversarial forms of system, so the aggrieved party need to visit to the court. So aggrieved party visit to the court, and it is called as a plaintiff is the party which is bringing a lawsuit before a court of law in pursuance of a legal remedy. Well, a defendant is a party against whom relief is sought in a civil proceeding. Well, this Code of Civil Procedure 1908 governs the procedure in relation to civil suits. Well, the code lays down the substantive and procedural aspects in the form of provisions and orders drafted in the code for regulating the proceedings in Code of Civil Judicature. Well, the orders provide for rule in regard to parties to the suits, framing the institution of suits, the particulars to be present in pleading, plaint, and written statements, pronouncement of judgment or decree, among others. Well, the code also provides rule regarding the grant of temporary and permanent injunction and summary procedures. Well, the alternate dispute resolution mechanism is path of litigation and use of court system to resolve the commercial disputes usually takes place year to resolve and cost a lot due to legal fees and expenses. Well, during the process of litigation, normal business operations are hampered and disrupted. So, in order to avoid these issues, the businesses usually prefer a mode of settlement without involving the courts. Well, here the disputes are resolved outside the court judicial system. This is often referred to as alternate dispute resolution, that is ADR. Well, ADR is being increasingly used to resolve legal problems as it provides many benefits in terms of quick redressal, well, and resolution, and much cheaper than the litigation. Well, ADR includes within its scope arbitration, negotiation, and mediation. So here you can see the life cycle, the negotiation. So in the negotiation, past events are dealt with in order to reach future agreements. Well, non-adversarial method, it's a non-adversarial method. Both sides win. They make compromises and look for an agreement that satisfies common interest. A third party does not intervene. The process is voluntary. The parties are those that resolve the situation. Well, as far as the mediation is concerned, try to reach an agreement to improve future relationships. Non-adversarial method, both sides win. They look for mutual understanding and collaborate to reach an agreement that both sides find satisfactory. While a third party intervenes and the mediator that controls the process and helps the parties well identify and satisfy their interest. Well, this is done among equals. The process is again voluntary. The mediator proposes solutions and party resolve the situation. Well, as far as the conciliation is concerned, this is where past issues are resolved without the commitment for the future. Well, definitely it's also non-adversarial method, both sides win. Reconciliation is sought after. Well, a third party intervention bring both parties together to talk or transmit information between each other. Well, definitely it is also a process that is altogether voluntary. Well, definitely in the end the parties resolve the conflict. As far as the arbitration is concerned, post events are discussed and arbitrator makes a recommendation that parties can accept or reject. Well, adversarial methods, one side wins and other side may lose or loses. Third party intervenes. This tends to be person with more authority. Well, the process is definitely voluntary. The two sides present their needs, interest, and position to arbitrator. The sides are not autonomous when it comes to the result, as the result is imposed by the third party. Well, in the final, it is trial. The parties lose their power to resolve the conflict, adversarial method, and neutral third party intervenes the judge and judge dictates the sentence that ends the process and resolve the conflict. Well, the sentence or the judgment is mandatory in nature, so it holds weight, ties, and obliges, and definitely it is not a voluntary Well, let's move to the next block. It is the business forms and legislations, and it involves two units. One is Partnership Act of 1932, and another one is Companies Act of 2013. It involves the nature of definition, nature of partnership, its definition, various components, partners, forms names, how to establish essentials of partnership, types of partner, and in fact, position of a minor as a partner, types of partnership distribution from other forms like that. So, including rights and duties of partners, relationship of partners with third party, role of partners as an agent, authority of partners, reconstitution of firm, admission of partner, retirement, etc. And in the last leg of this unit, there is a concept of how to dissolve a firm or a business entity. Then the introduction of LLP that I mentioned in the previous session, previous slides. Well, differences with other form of organizations between LLP and forms like firm and so on. Then advantages and disadvantages of LLP and how to incorporate an LLP. Well, initially, we can look back the Indian Contract 1872, which is governed all aspect of commerce and trade under Chapter 9, Section 239 to 266 of the Act, regulated the partnership business. But these provisions were not exhaustive. Many aspects remained unnoticed and unregulated. This led to a need for more specific governance, and the government took a step to legislate further. Chapter 9, Section 239 to 266 are replaced by Indian Partnership Act 1932. It is based on English Partnership Act of 1890. Well, if we look for the nature of partnership. So first, look for the various components. Right? It may have partners, forms name, etc. So Section 4 of Indian Partnership Act 1932 lays down the definition of partnership: partner, firm, and firm name partnership. So partnership is a relationship between partners, persons who have agreed to share the profits of the business carried on by all or any of them acting for all. So here the important aspect is the business can be done by all or by one acting for all. So there are three aspects to partnership: partners, firms, firm name. A person who have entered into partnership with one another are called individually partners, and collectively they are called as firm. And the name under which the business is carried out is called as firm's name. Well, thus a firm in law is only a collective name of the partners of a partnership. Very interesting definition. So it doesn't have separate legal existence as in a corporation. Well, while acquiring the firm name, the partner should keep in mind that they do not violate the rules related to the trade name or goodwill. The adopted name must not mislead the public to confuse them with a firm of repute already in existence with a similar name. They must not use a name implying the sanction or patronage of a government. Definitely, so we cannot add the name of country or sort of thing. Well, a partnership firm cannot use the word limited as a part of its name. So there are certain guideline restrictions and the specification that need to follow while selecting the name as well. Well, there are certain essentials to partnership. Well, Section 4 of the Act indicate that the following elements should be there. Like there must be minimum two persons because if there is more than less than two, so there will not be a partnership. It will be a single person. So the mandatory requirement to have a partnership is more than minimum two person, more than one. So the relationship must arise out of an agreement between two or more persons to carry on a business. Well, the agreement must be to share the profits of a business. The business must be carried out by all or any of them acting for all. Well, each partner is liable for all the acts of a firm done by a partner. Well, the key points includes the association of two or more persons. The act is silent on the maximum number of partners. Well, it has been later defined in the Companies Act 2013 to various detailing purposes. Well, agreement under Section 5, the relation of partnership arises from contract and not from status. Thus, the members of a Hindu undivided family carrying on family business or Burmese Buddhist husband and wife carrying on business are not partners in such business. Well, business is defined in the section 2B of the Act. Well, sharing of profit is also a component, mutual agency is also a component, and then there is a liability of partners. Well, liability of a partner for acts of the firm is unlimited. That is, the partner's private assets can also be used for paying off the firm's debt. Well, here this was taken up in the LLB Act that liability is not unlimited. It is limited to the acts only or to the share that has been extended for the purpose also. So the partners may be of because we talk about the partner. So partner may be of various types. They basically two categories. One, partners by virtue of partnership, that is agreement, and partners by virtue of holding out. It is defined under section 28. Well, Act does not provide about the types of partner. This is decided on the partnership contract itself. In practice, based on extent of liability, the different classes of partners are, well, actual, active, or ostensible partner. They are actively participating in the functioning and management of the business and shares its profit or losses. Well, then there may be a sleeping partner, sleeping or dormant partner. They invest money and share profits, but do not participate in the functioning and management of the business. But they are liable to the, the third parties for all the acts of the firm. Such partners has no duties to perform, but is entitled to have access to books and accounts of the firm. Well, then there is a nominal partner. Neither invests nor participates in the management, but only gives his name. Well, he is also liable to third parties for all the acts of firms. They are required to give public notice at the time of being separated from the firm. Well, here we will be taking this point in the subsequent sections. Well, if a person, this nominal partner, fails to declare that he is no longer associated with the firm, so he is liable till that date. Partners in profit only, well, without being liable to share the losses, is called as partner in profits only. Thus, a person who has sufficient capital but is not prepared to take risk may be admitted to partnership. Whether the partners, in spite of his specific position, he continues to be liable to third parties for all acts of firm, just like other partners. Then there is a partner, not the partner in firm, partner of a partner, has no rights or duties toward the firm and does not carry any liability for the debts of the firm, can neither participate in partnership business nor check the accounts of such partner and claim share. Only right he has to share the profits in property at the time of winding up of the firm. Well, partners by estoppel or by holding out. This is an interesting category. If a person by his act or words gives another person reason to believe that he is a part in the firm, whereas actually he is not, and that other person takes action on those sets of facts, such a person is stopped uh, uh, from later on denying the liabilities for the acts of the firm. Such person is called partner by estoppel and is liable to all third parties. Similarly, when the firm declares a person to be partner when actually he is not, and the person knowingly permits himself to be represented to be a partner in the firm or does not deny the fact that he is a partner, then such a person is known as partner by holding out. Well, an active partner who fails to give public notice at the time of retirement is also liable. Well, we often see a couple of businesses where minors are admitted to the benefit of the partnership. So they can also act as a partner, but there are certain limitations or there are certain conditions that we can explore. Well, as we can see, the partnership is a contractual relationship. The parties to contract must be competent to contract, and we all understand that minor is incompetent to venture into such contract. Hence, he cannot become a partner, but with the consent of all the partners, he may be admitted to the benefits of the partnership. Well, there are certain rights of the minor and there are certain liabilities of the minor. Well, he is entitled to share the property and of the properties of the firm as agreed upon. He can have access to and inspect the copy of any of the accounts of the firm, but not any other. It is defined in section 30, subsection 2. Well, a minor can sue the partners for an account or payment of a share of the property or profits of the firm when severing his connection with the firm. The amount of his share shall be determined by the valuation made as far as possible in accordance with the rules contained in the section 48. Well, as far as the liabilities of the minor is concerned, a minor is liable to the extent of his share in the firm only. Well, he is neither personally liable nor is private assets liable for the acts of the firm. Well, he cannot be declared insolvent if the firm's debt cannot be paid out of the firm's property. Well, we all understand the situation of the minor in the minor phase, but when he attains the majority or major age, so then his position may change. So he has a choice to become a partner or sever his connection from the firm within 6 months of his attaining the age of majority, or when he comes to know of his being admitted to the benefits of a partnership, whichever date is later. Well, he has to give a public notice if he intends to become, or that he has elected not to become. He's not to become a partner in the firm within 6 months. He fails if he, in case he fails to give such notice, he shall become a partner in the firm on the expiry of said 6 months automatically. Well, subsection 5 of section 30. Where such person becomes well, his rights and liabilities as a minor continue to be up to date with which he become a partner. Well, he also becomes personally liable to third parties for all the acts on the firm done since he was admitted to the benefits of the partnership. Well, his share in the property and profits of the firm shall be the share of to which he was entitled as a minor. Well, where such persons elect or not to be a partner, his rights and liabilities shall continue to be those of a minor under this section up to the date on which he gives public notice. But his share shall not be liable for any acts of the firm done after the date of the notice, and he shall be entitled to sue the partners for his share of the property and profits. Well, then there may be various types of partnership. As I mentioned, that partners may be different types, but at the same time, the partnership may be also different types. Well, a partnership may be for the particular adventure or for a fixed period or at will. Well, from duration point of view, the partnership may be classified into two categories: one partnership at will, which is defined under section 7, and another one is partnership, particular partnership, which is defined in the section 8. Well, as far as the partnership at will is concerned, according to section 7 of the Act, no fixed period has been given, agreed upon for the duration of the partnership. So there is no provision made as to the determination of the partnership in any other way. So death or retirement of partner does not affect the existence of such partnership, provided that the partners are more than two. Because in case of death of one partner in two-member partnership, so definitely it leaves the concept of partner. It's inherent and obvious type of situation. Well, such partnerships can be dissolved by any partner giving notice in writing to all the other partners of the his intention to dissolve the firm under subsection 1 of section 43. Well, the firm is dissolved from the date mentioned in the notice at the date of dissolution, or if no such date is mentioned, as from the date of communication of the notice. Well, as far as the particular partnership is concerned, when a partnership is formed for a particular adventure or undertaking or for a particular period, such a partnership can be called as particular partnership. Such partnership automatically comes to an end on the completion of venture or on expiry of the period. If partners want to dissolve the partnership before fixed period, it can be done by mutual consent, and if the partnership is continued after the expiry of term of completion of venture, it is deemed to be as a partnership at will. Well, partnerships distinguished from other forms of business. Well, like co-ownership and partnership, Hindu joint HUF, Hindu joint family firm and partnership. Well, as far as the co-ownership and partnership is concerned, if two or more persons own a property jointly and employ the same property in a business and share the profits, it is called as co-ownership and not partnership. The main point of distinction between the two is partnership always arises out of contract, expresses or implied, whereas co-ownership may arise from an agreement or by the operation of law or from status or any other way, example, co-heirs of the property, etc. Well, a partner is the agent of the other partner, but a co-owner is not the agent of the other co-owner. Well, partnership involves sharing of profits and loss, whereas co-ownership does not necessarily do so. Well, a partner cannot transfer his rights and interests to anyone without the consent of all the partners. However, co-owner can do so without the consent of the others. A partner can only ask for share of profits out of the properties, where a co-owner can ask for division of the property. Well, a partner has a lien on the firm property, whereas co-owner does not have. Well, as far as the Hindu joint family form and partnership is concerned, well, HUF form differs from partnership in the following ways. Well, a partnership arises out of contract and HUF form out of status, that is, by birth in the family. Well, partnership is governed by Indian Partnership Act and HUF is by Hindu law, where a minor cannot be a partner, although he may be admitted to the benefit of partnership. Whereas in HUF, a minor is a member from the very day of his birth by virtue of his status, but he is not personally liable. Well, the death of a partner dissolves the partnership, but the death of a co-partner does not. In partnership, each partner has implied authority to borrow and bind other partner, but the HUF form, only the Karta or the manager who is the head of the family is entitled to do so. Well, in partnership, each partner has implied authority to borrow and bind other partner, but in HUF, form only Karta. Well, every partner is personally liable to the debts of the firm, but in HUF business only Karta. Well, partner can demand the accounts of the firm, and co-partner cannot ask for accounts. His only duty is to ask for partition of the assets of the family firm. Well, partnership firm must be registered before it can maintain suits against outsider, whereas HUF no registration is required. Every partner has a definite share and it can be changed from only by agreement, but the share of co-partner enlarges or reduces depending on death or birth of in the family. Well, there is a definite limit to the number of partners, but there is no such limit in case of HUF. Well, as far as the formation and registration of partnership is concerned, well, for formation of partnership, it comes into existence by contract, and this contract may be written or oral or implied, which is inferred from the conduct of parties in the business circumstances. Well, according to the definition of the partnership under the Indian Partnership Act 1982, there must be an agreement between the partners of the partnership firm. To constitute a valid contract, the parties to the contract must be competent to contract. The consent must be free and objective should not be forbidden by the law or immoral or opposed to public policy. However, two exceptions may be noted. A minor may be admitted to the benefits of the existing partnership firm with the consent of all the members or partners. Well, as relation of partners inter se are that of agency, no consideration is required to create the partnership. Well, then there is a concept of partnership deed. It is a document. It may be written or it may be oral, but usually it is advised to have a written one because to avoid any future disputes, as well as to address the legal issues, including opening of banking operations, including taxation purposes. It is advised to have a written agreement also. Well, this written document contains the mutual rights and obligations of partner, and it is known as partnership deed. The deed must be stamped according to the provisions of the Indian Stamp Act, and copy of the same must be given to each partner. And at the time of registration, a copy of deed should be filed with the registrar of firms. The partnership deed is not a public document, therefore binds only third party so far as they have notice of it. Well, I wish to connect here is that I mentioned somewhere that LLP was introduced in 2008. So those documents are in public domain; they can be accessible. Whereas the partnership that is between the partners only. Well, the contents of partnership deed is concerned the exact terms of partnership deed or agreement will depend upon the circumstances, but generally follows certain covenants, and it involves those covenants include the first one include firm name, date of establishment, duration of partnership, full name, and permanent addresses of all the partners and the date when each partner joined the firm, nature and scope, business, etc. So similarly, there are certain covenants that should be there, including the provision for expulsion of a partner, provision regarding the allocation of business activities to be performed by individual partner, the arbitration clause for the settlement of disputes. The term contained in the partnership deed may be varied with the consent of all the parties, and such consents may be express or implied by course of dealing, as explained in the section subsection 1 of section 11. Well, uh, it is advisable to register the partnership deed. So registration, although it's not mandatory in India, but if we register a document deeds, it puts into black and white all the intention and the purpose of partnership as well as its functioning. However, it is to be noted that registration only creates an instance of evidence of the existence of partnership and not a creation of legal entity. Registration means getting the firm registered with the registrar of the firm in the area where the business is situated or proposed to be started. Well, as far as the application for registration is concerned, it is very simple process, and it can be done by sending by post to or delivering to the registrar of the area, which any place of the business firm is situated or proposed to be situated. A statement in the prescribed form is prescribed with prescribed fee, stating the firm name, place, principal name, partners, and date from partner join, etc. So the statement shall be signed and verified by all the partners or by their agents, especially authorized in this behalf. It is mentioned in section 58. Well, registrar, on being duly satisfied, record the entirety of the statement in the register of firm and then issues a certificate of registration. The firm which is registered shall use the brackets and word registered immediately after its name. If any change is made in points A to F above, same should be duly notified to the registrar so that the name same is incorporated in the register of the firms. Well, what can be the effect? There can be certain effects of non-registration. Uh, well, as far as the effects of non-registration is concerned, so it is definitely not easy to file the suit, not able to claim certain benefits. So, in order to address this, we will be exploring that in coming session. So, with this, Namaskar.